Yes, that's correct. The decision in Safe Light Manufacturing v. C.E. Morgan Building emphasizes that when an oath is a statutory requirement, failure to make such an oath renders the entire proceeding void. The court in that case makes it clear that no amendment or cure can rectify a proceeding that was void from the start due to the lack of an oath. The principle from Mellon Bank NAV Coppage affirms this point, and Jordan v. Ford Motor Credit Co. Straw was overruled only in terms of curing defects in the pleadings, not in cases where no oath was made at all. So if an action is initiated without the required oath, any orders or rulings made by the judge in that proceeding would be void, as the entire proceeding is legally invalid from the outset due to this omission. If damages are incurred as a result of a judge's defective oath and no bond is in place, restitution could potentially be sought through a few legal avenues, depending on the jurisdiction and specific facts of the case. The absence of a bond complicates matters, but there are still options. 1. Civil lawsuit for damages, negligence, or misconduct. A party harmed by a judge's defective oath or misconduct may file a lawsuit seeking damages. This could be based on the theory that the judge acted outside of their judicial authority, ultra vires, especially if the oath was a legal requirement and it was ignored or improperly executed. Judges are typically granted judicial immunity from civil liability for acts performed within their official capacity. However, judicial immunity may not apply if the judge acted outside their jurisdiction or violated the law, e.g. proceeding without the required oath. 2. Claims against the government, state liability. If the judge is considered an agent of the state, the party may be able to bring a claim against the government for damages caused by the judge's defective oath, especially if there is a statutory or constitutional violation. Some states have specific statutes for filing claims against government entities. The doctrine of sovereign immunity may limit the liability of the state or judicial officers, but some states provide limited waivers of this immunity in cases of gross negligence, bad faith, or intentional misconduct. 3. Writ of mandamus or injunction. A writ of mandamus could be used to compel the proper authority to act according to the law, such as requiring the judge to rectify the defect. While not directly leading to financial restitution, this could help correct the judicial error. 4. Filing a complaint with judicial oversight bodies. Judicial misconduct could be reported to an oversight body, such as a Judicial Qualifications Commission or an equivalent entity. Although this wouldn't result in direct restitution, it could lead to disciplinary action against the judge and create grounds for an appeal or retrial of the case. 5. Restitution via appeals or vacated judgment. If the judge's lack of a proper oath or failure to meet legal obligations renders their orders void, you could seek to have the ruling overturned on appeal. Once overturned, you could argue for restitution based on the damages incurred due to the defective proceedings. Without a bond in place to ensure financial accountability, the best path for restitution would be through civil litigation, holding the judge or the state responsible, depending on the facts of the case and the applicable legal doctrines in your jurisdiction.